Well, good morning, everybody, and welcome to the Toolkit. I'm Dirk Webb. I'm the president and CEO of the St. Cloud Chamber of Commerce here in sunny Florida. Today, May 15th, we are welcoming Heidi Thompson of Lifeguarding Legacies, PLLC. We're going to talk estate planning, how to outsmart the villains. Before we get to Heidi, we need to thank our sponsors. First of all, the City of St. Cloud, Osceola County, Orlando Health St. Cloud, OUC, the reliable one, Osceola County Realtors, and Toho Water Authority, as well as Account on Us. So we invite you to make the toolkit part of your monthly business calendar. So let's talk a little bit about Heidi. Heidi focuses her legal practice on wills, trusts, and probate, but teaching, as she's told me, is a favorite part of her job. She graduated from Liberty University School of Law in 2007 and has a master's in educational counseling from Washington State University. Go Cougars, right? Heidi spent 15 years in public education as a counselor and behavior coach prior to starting her legal practice, Lifeguarding Legacies, in Arizona, then moving her practice here. Heidi is a Washington, Florida, Virgie Texacalzonian, also known as a GE Gypsy, as her husband's job with GE has moved them all over the country. I did okay with that, right?
You did great.
All right. Speaking of her husband, she's been married 34 years, Eric Thompson, who she's known since she was 11. I've taken it as my life's goal so far to make him laugh if I can. He has two grown children and two grandbabies that are the center of her universe. Fun fact, and I did the research on this, Heidi has actually been in movies and TV, with her most notable role in the season finale of A Thousand Ways to Die. Which one were you, number 999? And her most unlikely extras role in Straight Out of Compton. So I actually did the research, and that is the truth. So please welcome this morning our guest and great chamber member and ambassador, Heidi Thompson. Heidi, it's all yours.
Thank you so much. Well, let's just jump right in. Our voyage today is going to take us into why families drift into dangerous waters, the rules that are going to keep us afloat, the dangers that are hanging out beneath the surface, and the villains who exploit them, and then the most dangerous villain of all. And we're going to learn how to defeat every single one of them. But kind of before we get going too far, let me pull up. I have learned a couple of things about Florida. And, I am a lawyer and I have to get my legalese out of the way. Obviously, today's a workshop, not a law school class. Florida has a lot of nuances and exceptions and very fact-specific rules. So my goal today is not to turn everyone into estate planning attorneys, but it's to help you recognize the dangers, understand the big picture tools, and know when it's time to start the right conversations. I'm not going to be giving specific legal, tax, or financial advice for your personal situations. And please don't go home tonight and try to DIY your estate plan with a YouTube video and a notary. That's just not something I recommend. Do work with professionals that can help you apply these to your actual family assets and goals. Now, with that out of the way, I have learned a few things about Florida, and people here are really good for preparing for some things. Hurricanes, absolutely. Beach days, fully prepared. Disney strategy is like military precision. But I have noticed this. You might be a Florida planner if, it's going to click, your hurricane supplies are more organized than your legal documents. Your family's emergency plan is call Susan. She knows everything. Or your password system is try the dog's birthday. You ever use two screens and have the mouse set up to go the wrong way? This is fun. All right, here we go. Um, and now back over there. This is not looking the way I wanted it to. Is it gonna? Okay. I can't tell you how many families I've met who genuinely believed everything was handled. The parents were loving, they were responsible, they were organized, hardworking. They had a folder labeled somewhere important stuff. Then something happened. Sometimes it was death, sometimes it was a stroke, sometimes it was dementia, sometimes it was an accident that nobody saw coming. And suddenly the family realized nobody knows where the documents are. The bank can't talk to the kids, the medical providers won't release information, and the family members are trying to make major decisions while exhausted, grieving, and scared. That's not because they were bad people, and it's not because they didn't love each other. It's just because they drifted into dangerous waters without understanding what was beneath the surface. Because really, estate planning isn't about documents. It's about making sure your voice can still guide the people you love when you can't guide them anymore. So before we meet the dangers beneath that surface, we need one simple survival rule. Survival rule number one, die with nothing in just your name. So what does that look like? Everything you own should have a way to pass to someone else at death without involving the court system. So there's a lot of different ways to do this, and we'll get into details now. But for right now, just understand the big picture. Don't worry about writing all of this down, but remember the principle that everything has to have a place to go. Nothing gets stranded in just your name. For business owners, this applies to your company as well. So your LLC membership, corporation shares, or partnership interests need to have a clear transition plan, or your family will end up inheriting chaos instead of a business. A business can survive your death, but it can't survive confusion. So what happens when something doesn't have a place to go? So everything that you have should have a way to pass to someone else at death without the courts. And there's a lot of different ways to do this. So let's move on to the next. Um, all right. If something doesn't have a place to go, that's when we run into the first of our dangers of the deep, which is the ruthless raise of probate. Probate's the court process for transferring assets that are left solely in one person's name when they died. In Florida, that process can take a year or more. During that time, they can freeze assets. Creditors have a window when they get to file claims, and families are trying to navigate that paperwork while they're grieving. In Florida, attorneys can take a statutory fee that's 3% of the estate. It's not based on the work involved or the hours. And that's why we call these rays ruthless. And in Florida, that can really sting. Yes, Shalia, you're muted.
I'm sorry, I didn't have a question.
Okay.
I was just waving to a client.
Oh, okay. All right. No worries. Um, so a lot of families will find that they get surprised here because they thought that their will solved all those problems, which brings us to rule number two. The survival rule number two is a will by itself is not enough. Wills are important. They can name the guardians for your minor children. They can direct who receives your personal belongings and your pets and your other assets. But a will is not a great basket for your financial wealth. To understand why, it helps to understand a little bit what a will really is. A will is just a letter to the probate court. Ideally, it's a letter that the court never even opens. If we do our planning right and nothing is left named in our name when we die, then the court never even sees the letter because it never needs to be admitted into probate. But if we left any of our planning undone, then the chances are we're going to meet our first of the villains. Sorry, my mouse is driving me crazy. I'm really sorry. Here we go. This is Chaos. So, Chaos, I like him. He feeds primarily on unopened mail, mystery keys, expired passwords, and unlabeled file cabinets. He can smell a missing beneficiary from 3 counties away. He appears most often when someone says, I know mom had an account somewhere. I've seen surviving spouses, and this is sad, who didn't even know how to log into the business bank account. Not because the marriage was bad, but because one person just handled all the important stuff. And underneath the humor, here's the hard part. Families are trying to grieve while simultaneously having to become investigators. And as if that's not enough, sometimes Chaos likes to invite his cousin along for the fun. So, who? His cousin. Meet Gunner Grab It All. Now, sometimes the danger isn't actually in the paperwork. Sometimes the danger is in access. This is where Gunner Grab It All comes in. He usually shows up early. He has the garage code. He has the house key. He might have a spare key to the safe. And before the rest of the family even knows what's happening, he's already got the truck halfway loaded. Maybe dad did actually say to him, "Hey, someday, son, that fishing boat is yours." And maybe mom did always intend for him to receive certain family jewelry. But when nothing is written down clearly, then memories become super convenient. And grieving families become divided fast when that clarity disappears. Now, I'm going to tell you the truth. Gunnar Grabadall got his name from an actual client situation. I had a family member that I did an estate plan while he was in the hospital. And before he was even removed from the hospital, his nephew, who he trusted, had the gun safe loaded in the back of his car, along with a lot of other things. And that's where Gunner got his name. While chaos goes around creating confusion, Gunner takes advantage of that confusion. And the good news is both of these are actually pretty easy to defeat. So, how do we defeat chaos and Gunner grab it all? Well, we leave our families a roadmap instead of a scavenger hunt. It's not enough that you've got your documents filled out. It's not enough that every asset has a place to go. Instead, you actually have to have a communication plan so that they know where everything is. And the access needs to be limited to the ones who are supposed to be managing that process. So if you've got a bunch of people who all have your garage code, probably time to change it. If you've got a bunch of people that all have extra keys, time to rekey or ask for them back. So that only a couple of, I know that seems harsh, but probably a good idea. You can absolutely create your own system for how to find all the documents. A good spreadsheet can do it with key passwords. If you use something like LastPass, then your spreadsheet only really needs how to log into the computer and your LastPass master password. So that can simplify some of that process. For my clients, I give them a lifetime access to a subscription that anyone can buy online. It's called mylifeandwishes.com. It allows you to upload your key documents. It allows you to put in key passwords. You can link bank accounts. It can actually be click here when I die. So you just send out a postcard that says, "Hey, in my sock drawer, you're going to find the master password for My Life and Wishes." Done. Problem solved. It's super easy. When you have a communication plan like this, then you're cutting off chaos at the knees, and you're leaving Gunner without your keys. Which is as your legacy lifeguard, I feel obligated to point out, you might be a Florida planner if you have 3 backup generators and 0 backup trustees. Your freezer inventory is better documented than your assets. Your spouse asks, "Honey, where's our trust?" To which you confidently answer, "Somewhere safe." Now, that last one, I got to tell you, I am forever relating to that one. I have hid more things in our house in someplace safe and then have trouble finding it. And the funny part is, almost every joke that we make today comes from something I've actually witnessed and watched families go through. Most assume that estate planning is mainly about death, but honestly, in many ways, death is the easy part. Incapacity is hard. Because when someone dies, we grieve. But when someone slowly loses their ability to make decisions and manage their own lives, when the bills still need to be paid and medical decisions still need to be made, and the families are emotionally exhausted, they're trying to hold everything together. Well, that's a different kind of pain altogether. And for business owners, like a lot of us in this room, incapacity can become a 5 alarm fire almost overnight because employees still need their paychecks, Clients still expect responses, vendors still expect payment, and the person knows how everything works may not be able to communicate all of a sudden. And if no planning was done ahead of time, then eventually making the decisions. Well, at that point, we end up getting the state making our decisions. We call this the jolting jellyfish of incapacity. And while we immediately start picturing aging parents, it can strike even the young. And here's something for parents to be aware of. At 18, your kids are legal adults. And that means we don't have a legal right to make decisions for them for their medical and financial needs unless they decide to authorize us to do it, which seems a little crazy because they're on our car insurance and things until they're 26 and they're on our health insurance. But legally, if they get in an accident on the way to college and we haven't done any of our paperwork yet, um, we may not be able to speak for them, and the state may be making their decisions just like they were a ward of the state. Which brings us to survival rule number 3. We need to protect our voices before we lose it. And for our parents, we need to make sure that we've preserved our kids' voice if they're dependent on us. If we fail to do this, then we might meet our next villain. Meet Fido. Fido can be a good dog or a bad dog. Fiduciary is the one who steps in if you become incapacitated and can no longer manage your medical, financial, or personal affairs. This is a state-appointed professional. And if you haven't planned who speaks for you, then the court chooses that person. And the terrifying part is, while your family is trying to help, they don't have that legal authority to act, which can mean court proceedings, delays, expense, and then strangers suddenly involved in deeply personal situations. Thankfully, the tools to defeat this villain are super straightforward. A good estate plan makes sure your voice is still guiding your life, even when you can't speak for yourself. And here are the core Florida incapacity documents. In different states, they take on slightly different names, but the key is it's the names. The names don't matter as much as the function. You have someone who can speak for you medically, someone who can speak for you financially. Your wishes are clear. We authorize who can talk to hospital personnel, and we say what we want done at the end of our lives so that we're not leaving the really heavy decisions on the family members to make them if we don't have to. Now, if you've got a business, you must have an operating agreement with a succession plan. And so the operating agreement is kind of like a trust for your business. It's not just, well, my spouse can just step in legally. Not always. This isn't a great place to take your chances. As a business owner, you've probably spent years building systems to protect your business from competition, but very few systems are built to protect you from your own incapacity and death. And yet one of those outcomes is statistically guaranteed. So a clear operating agreement that addresses what happens for you if you become incapacitated or die, with who's taking over what files, if there's another professional that has to step in, who's doing that. And since we just said it's kind of like a trust, maybe it's time to move on to that, to the things that we're familiar with. So we already talked a little bit about wills and that they're just a letter to the court that says who gets our stuff. But let's talk about trusts. They're a little different. These days, you usually will only hear people talk about revocable living trusts. Revocable meaning you can change it during your lifetime. Living meaning it doesn't die when you do, which means anything you put in it doesn't have to go to probate because it wasn't left in just your name. So a trust is more like building your own set of instructions and choosing your own manager ahead of time. So while you're alive and healthy, you stay in control. It uses your own social security number, so you're not having to do anything fancy with your assets. There's no different tax filings while you're alive. If something happens to you, then the person that you designated steps in to manage things for the people, for you if you're incapacitated, and for the people you love when you're gone. And it kind of ensures that all of that is communicated in one organized method. The other benefit things are private in a trust because it's really just a contract between you, and you, instead of a letter to the court. And it's usually less stressful on the people that are left behind. So let's talk about what goes where if you have a will to avoid probate, and what goes where if you have a trust. So if you have a will, you're going to see there's three different sizes of buckets. First, it's the non-probate bucket. This is making sure that the things that can have beneficiaries have them. So your IRAs, your investment accounts, your insurance, they all have beneficiaries set up ahead of time. And I know many people don't realize this, but if you walk into your bank and set up an account, they never ask you, hey, who should take over the bank account when you're no longer here? But if you ask them, hey, I'd like to put a beneficiary on my bank account, they can do it. They call it payable on death or transfer on death. Some of them will call it POD or TOD. But it's a form you fill out that says this person or these people get a check when I'm gone. Now, just for important note here, that works for when you're gone. That doesn't work during incapacity. So you still need to have someone on file at the bank who can access those funds for you if you're incapacitated. So if you've got a will, that first bucket is a two-step. It's payable on death and power of attorney. It's not a one-step. Okay, if you've got a will, then your real estate is going to be passing by deed, by some form of survivorship. In Florida, we have ladybird deeds. So if it says, my house is mine while I'm alive, and when I'm dead, it goes to these people. And it's a valid instrument that avoids probate all the way around. If you're married, a tenancy by the entirety's deed says that the surviving spouse receives it and they get a little bit of a tax benefit in it. So that's a good way to go in Florida. And of course, if you've got business property or a rental property, usually we're going to recommend that that's held in an LLC. Personal property, only the tangible stuff in your house and your car. That's the only part that should pass under a will. And you'll see that's our tiniest bucket. So that's how we avoid probate. Because if only the house and car are passing, if only the stuff in your house and your car are passing by the will, then the DMV sees your will to give the car transfer, not the court. And the tangible stuff just goes, the court doesn't even see it. So this is how the letter never even gets opened with a will. Now, trust, there's only two buckets. The IRAs and 401ks pass to the beneficiaries on file because they get terrible tax treatment inside a trust. Everything else can go right into the trust. Your bank accounts go in the trust, your real estate goes in the trust, or LLCs if they're business related. Life insurance can be payable as the beneficiary to the trust. Your cars can be titled in the trust. And we do a one-page form that says all my household things go in the trust. And the trust is a one-step shop for incapacity because your trustee takes over everything that's in the trust when you're incapacitated and can just manage it for you without having to put that second step on file at the bank. So that's it. Small bucket, big bucket. IRAs and 401ks, the taxable things outside, everything else in the trust. All right. So we mentioned a little bit about survivorship deeds when we were talking about the wills. I want to bring up survival rule 4. And if you can see my face, I'm going to do a visual that I know you're going to remember. We never do joints with a non-spouse, okay? Joint title on a house, joint bank accounts, joint cars. If it's not your spouse, to have something jointly is jointly liable, which means if mom thought it was a great idea to put her kid on a deed because someone at the bank thought it was a good idea that it would make it easy and avoid probate. So they put their kid on the house as a joint owner. Well, now your kid gets in a car accident and gets sued. Guess where the lien goes? On your house. Thankfully, in Florida, we have some homestead protection, then it's not going to take the house. But after we're gone, that lien is going to sit there. It's not a pretty sight. In some states, that means they can take the house. You put your kid on a joint account, your kid gets sued, that account is attached to that lawsuit, you can lose everything in that account. So we don't recommend joints with a non-spouse. We already mentioned you can have a power of attorney on there for incapacity, so they can access it to help you. And we've got the payable on death so they can receive it when you're gone. Just don't make them a joint owner. If you've already done that, please fix it if you can. If you need someone to help you in Florida or talk to me, we can help. All right, which brings us to our next villain. This is Sue Hugh. Um, yeah, and if you've done a good job with your assets, so your kids aren't joined on title, you're not going to meet Sue in that capacity. But let's say you have a rental property and it's just in your name, and someone slips and falls on that rental property. Well, anything that's in your name, Sue can get at. So it's a really good idea. That's why we recommend LLCs for rental property because that's a limited liability corporation. All they can get at in a lawsuit then is the equity in that house and the business account attached to that property. So it's a very good idea to do that. Um, that's the best ways to kind of protect yourself from Sue Hugh. All right, Sue comes along with our dangers of the deep that we call the circling sharks of litigation. The trust, a lot of people think that having a trust is going to protect you from these circling sharks of litigation. Thankfully, that's a useful myth that carries over from the 1990s. Back in the 1990s, people did a lot of irrevocable trust planning. And they did that because back then, if you had more than $600,000 in your estate, everything above 600,000 was taxable. So they would do these irrevocable trusts where they would put property in something they no longer control, that's not in their name, where they're not the beneficiary of it, to push it out of their estate so it wouldn't be taxed. Well, irrevocable trust planning means you can't change it. So people never really liked this, but this was a tax play. And because it wasn't owned for them, it wasn't part of what people could get at. So at the time, there was this great idea that having a trust would protect you from litigation. And thankfully, there's still some carryover in this myth. But with revocable living trusts, where you are in control, and it is you, and it is your social security number, there really isn't any legal protection anymore in a trust. In fact, a trust is a little bit like bringing a beach umbrella to a hurricane. It's just not the right tool for the danger. Okay. Beach umbrella is great to protect you from the sun. It's not going to do much to protect you from a hurricane. Revocable living trusts are a wonderful tool for probate avoidance, organization, incapacity planning, and protecting your beneficiaries from themselves. But protecting from lawsuits, no, that's really not the right tool. We really need to have those rental and business properties and LLCs. We need to have homestead on our house to protect our own house. And honestly, the other big protection is umbrella insurance. So if you carry good car insurance, usually with the higher limits because you've got some net worth that you've built up in your life, it's not that much more to go to your car insurance and homeowners insurance person and say, hey, I want an umbrella that covers my entire net worth. Then, if someone sues you, you've really got a protection from that lawsuit. Now, I don't sell umbrella insurance, so I'm not trying to sell you on this, but it's an important component when you're doing your planning. And it's an umbrella that is super important. So in some case, really, the umbrella really is the right tool against the hurricane. So punch open that umbrella because it's about to rain another edition of You Might Be a Florida Planner. You might be a Florida planner if your LLC operating agreement exists as, it's a conversation we once had. Your estate plan accidentally includes three exes and a deceased cousin, or your children all think a different sibling is in charge. Ooh, okay. Siblings in charge. Well, sibling rivalries from childhood have weird ways of resurfacing, especially when a parent dies. Family businesses can really explode here when one child worked in the business and the others are still expecting some equal ownership. And interestingly, sometimes the fighting isn't even over money. It's over dad's guitar or grandma's sewing machine. That was my family story, is the sewing machine. And underneath it all, There are years of emotional baggage long before any legal battle even starts, which is why we have survival rule number 5. Don't trust your children. Now, before anybody panics or starts rewriting your Christmas list, I'm not saying your children are bad people. What I am saying is that grief, stress, spouses, addiction, resentment, favoritism, burnout, and old sibling dynamics can create all kinds of tremendous pressure. And sometimes in that process, we unintentionally place our kids in positions that expose them to conflict, liability, and temptation that they just weren't prepared for. I call this the war waging eels of family strife. In my own family, it was Grandma's sewing machine, which was probably worth $40 on its very best day. But my grandmother was a seamstress and it defined her. She made all of our Halloween costumes growing up. She made us beautiful dolls. She sewed bridal dresses for a season professionally. She would have me stand on a block while she fitted those. It was special, special memories. But when she passed, one of the sisters, there were 3 sisters living, one of them already had possession of the sewing machine. One was promised it, and of course, the other one wanted it. There's still a little bit of underlying resentment 20 years later that's still there over this $40 sewing machine. Clarity and distribution will go a long way to avoiding this, but putting kids in power positions will sometimes spark those rivalries. The reality is, families are complicated, and some of the family is not even the family you birthed or chose. Which brings us to our next villain. Oh, come on. Meet, do you divorce him? You love your son, but you just don't trust his picker. Sometimes the danger isn't in your child, it's in who they married. A properly designed trust can protect those inheritances from divorces, lawsuits, creditors, and bad relationship decisions. And if you really want awkward Thanksgiving dinners, you can even require a prenup before distributions. Here's something you may not even realize. Part of the power of a trust is its protection, not for you, but for your kids. Again, we talked about the trust doesn't protect you from lawsuits, but when you're gone, that trust now does become irrevocable. So then it creates a level of protection over your kids. If your kids are not the acting trustee, you put someone else besides them in charge, then that trustee can actually shield their inheritances from lawsuits, bankruptcies, and divorces. They can pay their bills directly, send them on a nice cruise, buy them a boat, do all of those kinds of things without anything ever hitting the bank account that's attached to a bankruptcy or a divorce. And in any case, if you trust your kids to manage that assets, you got to do that with some caution because the child who's the most responsible will end up carrying that emotional burden where a neutral third party could have taken that weight off of their shoulders, kept the war from breaking out, and still kind of kept everyone at ease. I call some of this inheritance stupidity insurance that comes free in every trust for your kids. Since we're talking about protecting those inheritances, let's talk about what happens when life keeps moving after you're gone. I want you to meet Gwenna Golddig. This is something you probably haven't even thought about, but um, sometimes the danger, let's see, whoops, after you're gone, Gwenna Golddig. I went to the wrong slide on my side, sorry. You leave everything to your spouse outright because, of course, you trust them, and that works beautifully. But sometimes your spouse eventually remarries. So this is your husband's next wife. Gwen may be a wonderful person, but she was never the person that you chose to enjoy the works of the fruits of your labor that you built for your children and grandchildren. And suddenly your children's inheritance is sitting one health crisis, one rewrite, and one bad influence away from a completely different outcome than you intended. You can actually write into your trust a prenup that can ensure that Gwen A's cared for, but her inheritance is kind of kept at arm's length. And there's another relative that we also want to make sure doesn't get a seat at the dinner table. Meet Uncle Sam. The good news is for most of us in Florida, when it comes to estate planning, Uncle Sam's mostly retired. People retire here because Florida doesn't have income or estate taxes. Now, for some states, you absolutely do have estate taxes, and some of them kick in at shockingly low numbers. Nod to you, Maureen. In Oregon, estate taxes begin at $1 million. Okay, if you own property, businesses, or rentals in multiple states, things can get complicated very quickly. For Florida, only the federal rules apply, which means when you die, your estate doesn't get taxed unless the total value as a single person is more than $15 million. As a married couple, it's $30 million. When the first spouse dies, you can pull in that first spouse's 15 to have 30 total when you're gone. So even if it was 40 when the first spouse died, no problem. Spend down 10, have a great life, get it down to 30. All right. Above that, though, if there's more than 30 left and you didn't do some real fancy planning, the federal government does take 40%. So when people say that rich people don't pay, they do when they die. Most of us, though, we live very comfortably under the $30 million married mark. And most of our assets are going to get a stepped up basis at value to the value at the date of death, which means capital gains aren't going to apply to most of the things we have. So the only tax considerations we even have to really think about are 401ks and IRAs, which remember you didn't pay taxes when you took them out. So the taxes come out when you pass, and they're going to be taxed as income to your beneficiaries within 10 years of your death. So they're not a great inheritance vehicle. So, well, I did my duty discussing death and taxes, which means it's time to lighten things up a little bit more with another round of You Might Be a Florida Planner. You might be a Florida planner if you named your trust Dad's Last Dollar and treat that like a challenge. You might be a Florida planner if you change your mind about beneficiaries more often than you change your pool filter. You might be a Florida planner if your kids are more excited about inheriting your Disney pin collections than you are your vacation ownership. Ooh, that's the truth. And I fell for a few free breakfasts myself. You might be a Florida planner if your estate plan is currently, I won't be there to worry about it. Underneath that humor, most people don't avoid estate planning because they don't care. They avoid it because it feels overwhelming, uncomfortable, expensive, or easy to put off, which reminds me, there's just one villain you haven't met yet. Meet Jess Put It Off. Jess is the villain that empowers all of the others. He tells good people next month, after tax season, after vacation, after the remodel, after soccer season, after retirement. Jess convinces loving families that there will always be more time. And honestly, most estate planning disasters don't happen because people didn't care. They happen because life got busy and Jess convinced them they could deal with it later. But the good news, if you're breathing and you have capacity, you haven't missed a deadline. Because when the time comes, your plan must speak for you. Hopefully, it will speak with clarity, love, protection, and peace. And if today caused you to start that conversation to talk about these things, then we've done something really important today. Just don't let Jess Put It Off win. If you would like to continue the conversation, there's two easy ways to do that. You can download a free copy of my book online. It's called Lifeguard Your Legacy. I have two versions of this book, What Every Floridian Should Know About Estate Planning. That one just came out last month, and it's very up to date. I have an Arizona version as well. It's from 2020. It's got a couple things in it when it talks about numbers that are a little off on small estates, but otherwise it still applies. And if you want to schedule a Q&A call and just ask some more personal questions, I do those for free using that QR code. But I'm also going to hang out here for as long as Dirk lets me, and as long as people have questions. So feel free to fire away. If there's anything you want me to revisit, I'm happy to do it. Dirk, all yours.
Thank you, Heidi. That was amazing. So the time we spent putting this promotion together for this event, I got to really be curious about these characters, and I love them. Some great information in there. So many of us are underplanned, and we do tend to push it off because it's unpleasant to talk about, or it may bring up some arguments that we'd rather not have, or discussions that we'd rather not have. So what I would like to do now is go ahead and stop the recording,
Okay.
and then we will allow folks to just continue on with questions and answers after we stop the recording, because I'm sure you don't want your questions recorded for everyone to hear on your business. So thank you again to Heidi for a great presentation, and to all of our sponsors. We remind you to make the toolkit part of your monthly engagement with the chamber. So I'm going to stop the